My name is Muzaffar Chishti. I work for MPI in Director's Office at NYU School of Law. You have our bios of all our distinguished speakers. I will not really use any time to repeat it. None of them need an introduction. But they come from three very important perspectives on this debate. And this is obviously a law and policy conference. I think we'll discuss a little more law than we have discussed in other panels, and hopefully a little policy as well. So the broad theme we picked for this panel, which I think we have detected has been true for a lot of immigration stuff since at least this president took over, is that some very important issues have been sort of getting shuttled between and among three branches of the government. In one way of saying, these are volleying from one branch of the government. You could also say each branch of the government is sort of putting the can in the other person's lap and hoping the can will stop there somewhere. And many of these cans haven't stopped. So this is our chance to see where the cans are and where they will finally land. So I'll begin this by asking questions of our panelists, more in a conversational style, so that we could get to many topics than sort of one issue only for a long time. So let me start with Cecilia, because she represents the ACLU, which many people regard has been the president's thorn in the side more than any other organization. Our last count is that the ACLU has brought more than 100 cases against this administration. Now, this is a law school. I'm sure every single law student here will salivate talking about all those 100 cases, but we'll stick to only 2 or 3. So if you don't mind starting with Daca, and I think this is at least one audience in which I don't have to say what Daca stands for. So start with Daca. The can has been shuttled by 3 branches of the government. The president ended the program. Lawsuit was brought almost the very next day to challenge the injunction. President said this is the job of Congress to do this, and David is here. He'll defend his institution. Congress landed up doing nothing because Congress could argue that the courts were busy, why they didn't need to intervene because courts have provided the protection. And finally, that can has to stop somewhere, and we believe it'll stop.
We passed the bill in the House. I just want to point that out. Nothing is a little inaccurate. I just want
that there will be. I'll give you full credit what happened in Congress, but it hasn't been resolved in Congress. So on November 12th, the Supreme Court is going to hear an argument on the Daca case. So Cecilia, just tee up for us. What are the challenges seeking in that case? What is the government's defense? How is the court going to rule, and when is it going to rule?
Sure. Thank you, Moose, and thank you to MPI and Clinic and Georgetown for inviting all of us to this conference. It's always very illuminating. So Moose mentioned that I work at the ACLU, and we have indeed filed over 100 immigration-related cases against the Trump administration, but the Daca rescission cases are not one of them. I am not actually one of the litigators on that case. I should make that important disclaimer, but I have spoken to many of the attorneys who are doing that, including folks from the National Immigration Law Center, from the state of California, from other states and municipalities, Make the Road New York, et cetera, et cetera. The takeaway that I would highlight, both from the Daca rescission cases that are at the Supreme Court now, as well as from every other major immigration initiative of the Trump administration. I'd include the Muslim ban, a whole cluster of asylum-related policy changes, the public charge rule, rescission of Daca, and also sanctuary city policies of this administration. The lesson from all of the many court battles over all of those issues are twofold. The first lesson is that litigation in support of immigrant communities has never been more important than it has been under the Trump administration. So for all you Georgetown and other law school students here, you're in the right place, doing the right thing to get ready to do more of the right thing. Even when we have unfortunately lost, as with the Muslim ban, where we got injunctions from all of the lower federal courts, but ultimately the state of Hawaii lost in the Supreme Court, We bought time for people. In the case of the Muslim ban, countless people were able to get to the deathbed of a loved one here in the United States, attend someone's graduation, be there for the birth of a child, be at an important academic conference or business meeting, et cetera, et cetera. In the case of the rescission of Daca, I'm actually quite optimistic about the Daca case. Don't shake that, please. I'm quite optimistic, but even if the Supreme Court were to rule against all of the immigrant groups and states and municipalities who are harmed by the rescission of Daca, that kind of litigation, even when unsuccessful, has so many consequences to protect people. Again, to buy people a little more time, buy people some more time with documented status, DACA-mented status. And it's been a really important vehicle, I think, to talk about how we think in this country about immigration. It's important to look at the ways that the asylum issue has been framed, mistakes that people in our own movement, in the immigrants' rights movement, have made, mistakes that we've made in talking about path to legal status and citizenship in the past. Dreamers themselves have been in the lead, both as clients in litigation, as litigants, and as advocates in their own right in pointing out some of those mistakes with respect to people who are already in the United States and lack lawful status. So that's lesson one. Lesson two is kind of the flip side. The big lesson of most of these cases, remember, most of these cases raise claims under the Administrative Procedure Act. Most of these cases are about the abuse of executive authority, about the Trump administration taking to an extreme, an illegal extreme, laws, the application of laws that are already on the books. And so lesson two is that we cannot rely on the professed goodwill of the executive branch, even when we believe we have friends in the executive branch. We cannot rely on executive branch officials to comport with unwritten norms. Enforcement laws that are repeatedly subject to abusive, illegal, and immoral application must be struck from the books one way or another. And that's the second lesson from the Trump administration. The way I see it is that with all of these policies I've mentioned, starting with the Muslim ban and the president's exercise of his statutory authority under INA Section 212F, which again was the basis for his action with the asylum ban proclamation, he's been picking up loaded guns that are lying around in the Immigration and Nationality Act and in the jurisprudence of plenary power and other old Supreme Court precedents. And to be clear, I should be really clear about one thing as a litigator. All of the policies that our movement has challenged in litigation by the Trump administration are illegal under existing law. Okay, I'm not taking the position that statutes need to change or precedents need to be overturned in order to challenge the legality of these Trump administration policies. But if we no longer want these loaded weapons to be lying around for the next Donald Trump, the next abusive white nationalist, I don't say that lightly, okay, but let's face it, these are white nationalist policies, then we need to exercise the will of the people to make sure that the loaded guns are disarmed. In addition to 212F, we've seen this administration try to abuse expedited removal to the statutory maximum, which all previous administrations in both parties have put out the conventional wisdom exceeds the bounds of due process. the public charge ground for inadmissibility, obviously, which we'll talk about on this panel. Mass detention, including detention without any individualized hearing. Exceptional under U.S. law and civil detention. Immigration detention is the only area in U.S. law where civil detention can be imposed without an individualized hearing on flight risk and danger. Extraordinary, and yet that's been approved by the Supreme Court so far. And efforts to limit Article III court review of removal orders. That also has been something that the Trump administration, like its predecessors, has raised in all of this systemic litigation to challenge these policy moves. So I think going forward, and I know David and Kate will talk more about this along with Moose, we really need to uproot the frame of lawbreaking that has infected immigration policy making since 1996, most pertinently, both from the law and from our framing of the policy debate. No more get right with the law, okay? No more securing the borders so that we can legalize the status of people in the country already. We really need to look at the people as human beings and look at our system as one that should be imbued with due process and individualized scrutiny of people as individual human beings. That's my takeaway.
Okay, thank you. So, but just fill us up. So the case is going to be argued on November 12th. Now, you have argued before the Supreme Court very skillfully, but you're not arguing this case.
But I lost.
I hear there was a surprise choice to do this argument. Mm-hmm. Could you tell me who it is and how the choice was made?
Sure. Again, I'm not one of the litigants, but I was peripherally involved in discussions about this. So you probably all know that Ted Olson, noted conservative and member of the Supreme Court bar, will be arguing the case in support of Daca and against the rescission of Daca. And it was an interesting, and I have to say somewhat painful discussion. There were, what is it, seven separate lawsuits coming out of 3 different districts, federal district courts that are consolidated in the Supreme Court. And states and municipalities, I should add, Michael Mongan, who is the Solicitor General of California, will be splitting the argument with Ted Olson if pending Supreme Court, contingent on Supreme Court approval. That's the proposal that the respondents have made. And, this is what happens when our issues get to the Supreme Court. Nancy Moravec is someone who's talked a lot about this dynamic where we have a very entrenched Supreme Court bar that is not very diverse, that doesn't necessarily represent movements when movement cases make it to the court. And so there was a pretty fraught discussion, I think, it's no secret, among the various groups of counsel and parties. And Ted Olson, to give credit where credit is due, is someone who I think is a choice calculated to appeal to as broad a group of justices as possible. It's a decision calculated to win a majority. But I must say that as someone who is a movement, an immigrants' rights movement lawyer, as a civil rights lawyer, as an ACLU lawyer, there are so many extraordinarily brilliant lawyers in our movement who could argue this case. And I have to just express my personal opinion that I think Ted Olson is an interesting and a brilliant choice in many ways, but I also feel some regrets, I guess. Not regrets, since it wasn't my decision, but a little sad that we don't have a movement lawyer up there.
So you said that you're optimistic about the Daca case. Could you tell me why you're optimistic when 3 or 4 years ago on the DAPA case, which had essentially same arguments, so we now know that the 4 conservative judges probably voted, though we'll never know about the vote because it was a tie decision, they probably voted to say DAPA was unlawful. Why would you think that Daca is going to be ruled as lawful when Daca was not seen as lawful? And DAPA was not seen lawful.
Obviously, the Supreme Court affirmed the Fifth Circuit by a 4-4 tie. I guess two-word answer, legal realism. I think that this case is a political one, like many hot-button cases in front of the Supreme Court. And I have to believe that there aren't going to be 5 justices who have the stomach to agree with the Trump administration on this one. I think we, have seen this court already rule in the census case the right way, and I think this too, DACA would be a road too far. To get to the technical reasons why this case is different, there is an argument that as to DAPA, the INA already provided a statutory provision for adjustment of the parents of dreamers, which isn't present here. And there's also a reliance interest that here we're talking about rescission of a program that was in effect for years already and that people have come to rely on that. And then finally, there is a dynamic here, continuing a pattern of the Solicitor General of the United States across several administrations, providing incorrect, let's say, data to the Supreme Court. There was an element here of the government, the Trump administration, saying that DACA was applied in the Texas case, in the DAPA case. The Trump administration took the position that the Obama administration had applied DACA in a boilerplate way, that basically everyone who met the qualifications for DACA under the Jay Johnson memo was getting relief, getting the deferred action. And they went into court and said that. Hainan, I think, relied on that. Judge Hainan, the Fifth Circuit, I believe, also relied on that. And so the argument here is that evidence since then has demonstrated that, in fact, the Obama administration was applying, the agency, both under Obama and under the Trump administration, was applying discretion. It wasn't a rubber stamp. They weren't handing out DACA to everybody. And so I think that correction or development of the record in the subsequent litigation will be important.
Great. So I'll let you off soon, but let's finish the 2 other things. So the public charge rule, which a lot of people here are concerned about, was going to go into effect. There were 9 lawsuits brought to tell you about how there are good fallouts from the Trump administration. 14 attorneys general of the United States brought an action against public charge. It's active litigation. I heard there was very lively argument at the Southern District in New York this morning. So could you tell us what your view on the public charge challenge is and what's the timeline that people should be looking at?
Sure. So again, a disclaimer, we are not involved in the public charge litigation. None of the 100+ cases is the public charge case. But I did speak to Nico Espiritu from NILC this morning to get his readout from the Northern District of California hearing, which took place last week. I think as to timeline, I think almost all the litigants, maybe with the exception of one of the cases, has sought a preliminary injunction. The idea is to get the rule enjoined before the October 15th effective date. As you told me, since I was on the train this morning and wasn't looking, I was preparing for this, not looking at the news, that the readout from New York was positive for the challengers. The readout was also positive on the Northern District of California case. I will say that in the Northern District of California, the district judge did express some concern about the request for a nationwide injunction. She has requested additional briefing on the scope of injunction, had urged the parties to try to reach an agreement on the scope of injunction, which I don't think is going to happen based on no inside information. It's interesting. We've seen the Ninth Circuit and the forced return to Mexico case, which is an ACLU case, limit the preliminary injunction we had gotten from the district court, which was nationwide in scope, to the Ninth Circuit. And so I think what you may see, if we can read the tea leaves from the argument in front of Judge Hamilton, is that she may be preemptively trying to narrow the geographical scope of the injunction.
Okay, but last on this, because we talked about asylum a lot, good part of this conference. And I think many of us are surprised by the Supreme Court letting go ahead the new rule on the transit country need to apply for asylum there. How do you read that affecting the decision of the court on the merits when it comes?
Well, the Supreme Court didn't purport to rule on the merits at all. And so I think we have to take them at their word on that and continue to litigate it. The stay, there's no getting around the fact that the stay order is painful. We've got a situation where, as the previous panels went through in greater detail, we had the first asylum ban proclamation, which funneled everyone through ports of entry. Then the administration was bottlenecking asylum applications there. Then they did return to Mexico, which has led to, estimates of 20,000 people, including kids, stuck in Mexico, sleeping on the ground, outdoors, and then the third country resettlement proclamation. And it hurts because we are desperate to get relief for people who deserve to have asylum in our country and who've been turned away in every possible juncture by this administration. So, I think we take the Supreme Court at its word. We keep going with the litigation, keep litigating it, and build our record to show the harms to our clients, and that's it.
Okay, David, now your turn. You are, as just you represent the will of the people in Congress. So, you really by now have one of the more interesting places in this debate. You've spent a lot of time in the administration. You've now spent
the last
time
administration, please.
on the Hill, both as minority and as majority counsel. And so just start with the DACA thing, because obviously the hope was that Congress would intervene in the DACA case. First on the budget, which it decided not to do. But because the litigation was going, people were protected, and that's sort of going to end, as we now discuss, at some point. But you did also manage to pass a really impressive legislation on the House, and it got nowhere in the Senate. So let me ask you two questions.
Sure.
If the Supreme Court rules that the end of DACA was lawful, what do you think the Congress is going to do?
Sure.
And even if the Supreme Court says it was unlawful, what do you think the court will do, or will it feel off the pressure?
Sure. So if I can just address, so first of all, thank you to MPI, to Clinic, to Georgetown. I appreciate the invitation. So one, I want to say that I am not as positive, I'm not as optimistic, I should say, about the Supreme Court. I actually think the Supreme Court.
I'm not surprised.
I know, yeah.
This is like this is how we are.
Yeah. I am the pessimist in the room, normally am, yes. But I actually think that the Supreme Court probably doesn't even get to whether DACA is or is not lawful. I think what they do is they say that it is, my assumption, my guess is that they look at the memo that was originally issued. The memo itself says that it can be rescinded at any time, either to any individual in its entirety. They say if this is an act of prosecutorial discretion, you don't need to go through APA rulemaking to undo it, and they simply just do that and say whether it's lawful or not, the administration has the authority to end it, and they kick it back to the administration to set a timeline. That's my assumption as to what happens. That it's not what I want to happen. I've been anyway, but I just think that's the way it goes. So, if that were to happen, I hope that means that there is some real thoughtful, and some just some discussions between both sides about what to do, and how, I think there'll be a lot of Democrats that want to, of course, fix it, and there are lots of Republicans that want to do it. And the question is, how do they do it? And is there a trade? And is there the political space for one? I mean, that's one of the things that we found difficult when we even moved this dream bill, the one that we just did this at the beginning of this Congress. There were some on our side who wanted to kind of work on bipartisan legislation. There were others that wanted to do something that was more kind of pure and Democratic friendly and just take a one-sided approach and move that and kind of dare Republicans to vote against it. And that's kind of the path that we decided to take. But in the end, you are going to need to have Democrats and Republicans in both houses vote for it in order for it to become law and the president to sign it. And that may, in our system, require deal making. And the question is whether that space is there and whether people are, act in good faith to try to find a good deal that we can maybe not love, but all feel okay about. And I'm not certain that space is there on either side. And that would be unfortunate.
Yeah, but you're in the middle of the deal making a
Yeah.
lot.
Mm-hmm.
So what do you think the kind of things the Republicans will ask for a DACA deal to happen?
Yeah, so it's always been, it's always been about the border and about the either the asylum provisions or the unaccompanied children's provisions or other provisions that affect the ability to provide a law enforcement response to people who are coming across the border, is the way that they would put it. So usually it has been in that area where the discussions have really focused. But now with the Supreme Court taking a lot of pressure off of the border, I'm not sure what they come forward with. I mean, they may want to, perhaps knowing that that's an interim measure that's not likely going to be in place for longer than when the Supreme Court acts again. They might, see what they can, whether there's a way of adjusting the laws at the border, either when it comes to detention or how to treat asylum seekers or the remain in Mexico or something, to codify some pieces of it in some way. They might come forward with that. They may seek certain revisions to the immigration system, in eliminating family-based visas and moving them to employment-based or getting rid of the diversity visa program, and they may come with that. But their hearts are in the border and how to affect and deter. I mean, they want tools to be able to deter people from coming across the southern border.
I think it's not lost on any one of us that the decision is going to come out in the middle of an election season.
Yep.
Mm-hmm. So just put your political hat on. How do you think that's going to affect the dynamics in Congress on working on DACA?
Yeah, and then what if there's an impeachment on top of that? It's going to be, I have no idea how to predict that moves, to be honest with you. I mean, I've been around for a long time. I tend to have a decent sense as to what it is that Republicans want or where the deal-making space is and what maybe a good deal looks like, and that can get enough Republicans to pass in the House or, maybe gets Republican interest in the Senate. We're working on a different bill now, which I know we're going to talk about at the end, where we're trying to read the tea leaves right and navigate the channels. But here, I really don't know. I mean, I think things are so different now. Where the deals are in some of these areas are, I'm not sure I fully understand that. I'm not sure that there's anybody in the Hill that really does. Some of our normal partners that we would work with, like Senator Lindsey Graham, are just not in the same place at all, policy-wise or politically. I think that it's going to need people of good faith basically putting down their the weapons and coming and speaking privately to each other and trying to figure out what is good policy and that can, survive politically on both sides. But again, I mean, those conversations are not happening now. The groundwork for that isn't in place, and that makes me pretty sad right now. I think we're trying to build some of that right now because we know we need these good relationships in order to get things across the finish line later. So we're trying to build through other measures, but there's a lot of work to be done.
On the public charge issue,
Sure.
so do you think the Congress is likely to act or let the litigation run its course and not
Yeah.
deal with it?
Yeah, well, so, we've acted in certain ways. I just want, so we have, we filed comments, which I thought were very powerful comments, where we clearly think, and when I say we, I would just say the members that I work for, clearly think that the rule is illegal. It is far from the long-standing interpretation and the congressional, meaning behind the words public charge. I mean, public charge has always meant people who are destitute and can't survive but for, government housing and help, right? It was originally meant people that were, so destitute they were relegated to almshouses, or back then were called poorhouses, or insane asylums. Not people who can survive perfectly fine on their own, are working, but can use a little extra, health care or some nutritional assistance to improve the health outcomes of our communities. That is a bastardization of those words, and we feel very strongly about that. So, we did file pretty strong comments that laid out that legal argument and the congressional intent there. We were hoping that would help undergird and provide a foundation for the litigation. We have also drafted an amicus brief, and we're ready to file when the time is right at the appellate level. But this is a difficult issue, right? One, because it is, and we've taken strong stands, or there are bills that are there to undo the rule. We can always do a Congressional Review Act, but you do need both houses. And at this point in time, even if the House were to pass something, it is, I don't see a path in the Senate. I just will say one last thing about it. It is also, it is an issue that for many Democrats is not a difficult issue to talk about, but it's not true for all Democrats. And so then the question is, what do we do? And if not every Democrat is there, or every Democrat is comfortable taking that issue on, sometimes just doing something for public appearances' sake may not be the smartest move. So it's a very difficult. There are a lot of dynamics at play, but there are a lot of people that care a lot about it, and we are very much rooting for and trying to support the litigation right now. And I think we will have to take. We'll cross the bridge when we get to it.
Okay, crossing bridge to asylum. So there was a lot of
Yeah.
conversation here about asylum.
Sure.
And luckily DACA and the public charge stuff is stuck in litigation, so no one is being immediately harmed. But on the asylum, the impact is real and urgent now.
Yep.
Supreme Court let go ahead the new rule on the transit country.
Yep.
And the administration is busy signing these so-called third country agreements, which really don't meet any of the statutory requirement of a third country.
Correct.
A safe country requirement. So I think I'm representing a lot of feeling expressed here today that Congress sort of has been missing in action on the asylum issue. So what are you doing on this?
Take suggestions. I'm going to start for a little bit here. So we have done some things, right? I say that I work for two bosses, Mr. Nadler, the Judiciary Chair, and Ms. Lofgren, the Subcommittee Chair, the Immigration Subcommittee Chair. Ms. Lofgren introduced a bill that really sought to reform our entire refugee and asylum system in the hemisphere, creates an entire new framework for how to deal with refugees in our hemisphere, provides both assistance to sending countries, but also, provides assistance to other countries, so there's a regional approach, works with international partners, and provides, real refugee numbers for our hemisphere, so that there are other ways of coming and more humane ways of dealing with people and processing people who cross the border. So, we have tried to be leaders in that space, and we've held hearings on detention and on the treatment of families and children. We've had 3 hearings on the treatment of families and children at the border in our committee. And there are many other committees have come forward and have taken on. I've never seen any other committee in my 13-year history on the Hill ever want to take on an immigration issue. Usually, other committees are like, we don't want to deal with it. You deal with it. But now you've seen, other committees, government oversight and foreign affairs, tackle these issues. We had the armed services tackle an immigration issue in the hearing. We have lambasted the, you can't just lambaste the Supreme Court decision. We expressed our strong disappointment over it, and we do think that the decision is wrong as a legal matter. I agree with you that there are two ways in which you can deny asylum for someone who crosses through another country, and those are spelled out by statute, and those statutory requirements have not been met in these cases. And so I just don't, really understand, why why the Supreme Court did what it did. But here we are, and we're not going to get a decision, on the merits for quite some time. We can move a bill, and I think we are thinking about having hearings on this issue and maybe moving that bill or other bills in this space. But again, you'll get a bill maybe that comes out of the House, and then it'll die there. So, that's the best we can do right now when you have control of one House.
Okay, so Kim, let these two warriors now rest for a little while. I think really as a reflection of how much this debate has changed, that states were considered kind of side spectators to the immigration policy debate for a number of years, and I said 14 AGs have brought action on the public charge. So suddenly it's become a big issue for states. You represent the largest state in the country and run its social service program. So could you describe from your perch sort of how the developments in immigration, whether it's enforcement or the public charge, what kind of impact is it having on social services in a state like California?
Sure. No, thank you, and thank you for the invitation to be here as well. I'll start with just a little bit of context around California, just to have a sense of maybe why you see such passionate response and investment in a number of ways here that I'll talk about. 11 million of California's 40 million residents are foreign-born. 1 in 2 children in California has at least one immigrant parent. 35% of California's civilian workforce is comprised of immigrants, and immigrants are contributing $715 billion to California's economy. So in terms of California's commitment and response, immigrant integration is a big part of what we do. You may have heard our Governor Newsom's essential trademark, which is California for All. It's a home to many newcomers, and we certainly offer services that help immigrants become part of the social, economic, and civic fabric of our state. And so in that, it has been a busy couple of years, and certainly with this context and with knowing our population across the state, there is significant and real fear in communities. You've been hearing all day about impact on individuals and populations across the country, and certainly in California, we have seen that in the number and numerous policies that have come from the federal government. Specifically, just want to talk a little bit about response to public charge and kind of what we're seeing as proposed impact and what we're actually seeing as impact on the ground. I want to note that certainly it is our belief, and here's where we're in agreement with the Department of Homeland Security, in the actual rule for public charge, there's a recognition and an acknowledgement that the public charge rule may cause worse health outcomes, increased use of emergency rooms, increased prevalence of communicable diseases across the country, increased rates of poverty and instability, lack of productivity, and educational attainment. The analysis that we've conducted in California is similar, that we actually see that and are seeing the direct impact on health and well-being of individuals and families that are subject to it. But I would also state to you that it's not just those impacted and specifically called out in the rule, but also individuals who are not subject to public charge. And it's not just the public benefit programs that have been added to which programs would be considered, but it's also those who are participating in programs that it won't be considered. So the broad cast of impact and the complexities in interpretation that human service agencies across the country are needing to understand in terms of who it impacts and who it doesn't is significant. And we certainly have not spent time capacity building on human service providers of those intricacies. What we've done is we've invested in things like immigration, legal services, and remedies, right? $60 million investment this year, plus additional case management services that are focused on supporting populations to have an immigration remedy, whatever they might be eligible for. And that is the way in which they can also be a resource. But I think that, and there was just, I appreciate the comments from David as well, right? The public charge rule that stands today certainly recognized the health and well-being benefits, and who was targeted is different. So this is certainly going well above and beyond the intent, and certainly from a human service, social service perspective, the impact of our safety net on what it's actually supporting in terms of disrupting poverty is huge. Just the nutrition assistance program, supplemental nutrition assistance program, our SNAP program, is one of the largest anti-poverty programs in the country. It's included here, but it's not just about nutrition assistance, it's also about the improved math and reading skills that will be at effect, the longer term outcomes, low birth rates, increased graduation rates, and so forth, that really we see as an outcome of having things like a SNAP program. I also just want to say that there's some myths in terms of who's accessing these programs. Across the country, 87% of the SNAP recipients are households have a child, a senior, or a person with a disability. That's about 74% in California. So again, who's being targeted and served truly are the most vulnerable in making those connections. So in terms of public charge, in terms of what we're seeing across some of these other proposals, certainly we are anticipating and seeing disenrollment from programs, and therefore the ripple effect that means for health outcomes, again, not only for those who are specifically targeted in any of these given policies, but also those who aren't. It's just the broader health impacts of these policies across the state. And so it's significant. We have been very mindful and thoughtful about looking at enrollment and what we do about it. And certainly there is a complexity of even describing who it does and doesn't apply to, and again, like I said, which programs it applies to. But also we're just trying to make sure we have trusted messengers and communities that are partners with government in being that messenger, and having programs like two-generation approaches and home visiting to have the connections with families to talk through some of these complexities, and in fact, and sometimes enroll families or individuals that might be eligible for service. So it's a different strategy of kind of going into the weeds and detail of what's being proposed versus actually making sure we're doing our due diligence and connecting to the services that we know make a difference for people across the state.
Great. Let me ask you a question about the Daca and TPS if it ends. Obviously, the impact is going to be felt at the state level. What do you predict the impact is going to be on the state and on the residents? And is there a plan that the state of California has to respond to that?
So Daca for California has been tremendous. Just in the last 18 months alone, 574,000 individuals have renewed their Daca application. And again, I just mentioned the investment we had in immigration legal service providers to help assist with those renewals. We supported renewal fees as well. And so we've had a robust investment in helping people get engaged. And so the significant financial instability of households, I didn't mention most of our households households across the state are mixed households, so having a different status of various populations. That's 74% of our non-citizen populations in a household with a citizen. And so we just know that the impact of the financial hardship, I mean, the prediction and estimates in California is that California businesses would lose over $1 billion just in the turnover if DACA wasn't renewed. So it's a huge economic impact. I think also just studies that are showing the health impacts and the mental health impacts of the populations with the uncertainty of the program are real. And so that's also a concern of ours should that occur.
Yeah, let me ask you a kind of an obvious question. With the distrust of the government in general, especially among immigrant communities, especially during this administration, how is that affecting people's trusting the government of the state of California?
Sure. Yeah, as I mentioned, that partnership is key here. I mean, we have seen that. We've looked at a number of strategies to try to mitigate the disenrollment of benefits that we know are huge, again, in making an impact on people's lives. And in doing so, what we've also recognized is that the individual or family that walks into the social service office to disenroll in benefits, that we're trying to connect to that legal service provider to determine whether or not it's actually applicable to their circumstance, is a hard connection to make. That individual or family has made up their mind when they've walked into that office or made that phone call to disenroll. And so really, again, from our perspective, it's about getting in front of that. It's about, again, that connection where we have a number of rapid response networks across California with the Know Your Rights campaigns, and how do we ensure that the information about applicability of public charge and how to get those connections are happening with those trusted messengers and community. So it's certainly a public-private partnership from our perspective. And we are, in fact, even investing in some of our immigration funding in that kind of outreach to connect with individuals and families so that they understand what that is. But it is true that it's a real, the distrust is real, the fear is real in communities, and so that's how we've approached the
So just on the distrust, and I'll sneak in a question about census, because it was on our topic. Luckily, we dodged the bullet. The Supreme Court said that the citizenship question will no longer appear. But the narrative around that, is that affecting the level of participation that you expect in the census?
Yes, I think so. We have a number of investments in this space too, on how we conduct outreach, really recognizing what it means to have undercounts of populations here. And so it's a similar strategy in really engaging with trusted messengers, promotorist models, different models that are connecting with community, but it is absolutely a real thing. When I talk to the fear, we actually have those stories of individuals and families who truly are disengaging from any kind of community touch points at all, going without, and that's, I think, a huge impact. We're talking about going without some basic necessities and services, but also just not connecting at all with community. So it's a similar strategy that we're using in this space with the census too, of really looking at those community-based organizations and trusted messengers in community.
Okay, great. Let me just do another round with you folks before we get to the mics. So Cecilia, first, I mean, there was obviously a lot of euphoria soon after Trump came in, all these federal district courts all over the country issuing injunctions, people parading in the streets, but the dust has begun to settle as the cases have now come to the Supreme Court. Do you agree with that the Supreme Court at the end of the day is now going back to the traditional deference to executive authority? And is that a surprise given that there has been a lot of deference to executive in immigration for a very long time?
I think the answer is that the Supreme Court has a mixed record at this point on Trump administration policies. As you already pointed out, we won the census case, which was an ACLU case, I should point out. And, it was, the census case is an interesting counterpoint to Trump versus Hawaii, right? Because in both cases, you had a record which showed cabinet level and lower officials trying to make up a rationale to justify the official action when the president was saying what he says on Twitter and in other public fora. And so, in the Muslim ban case, we saw really a cynical decision, I think. Cynical in that the majority opinion purported to overrule Korematsu after 80 plus years, around 80 years. But in reaching its decision on the Muslim ban, reified Korematsu in so many ways. It was really undeniable. And I don't have the quote in front of me, but it was very telling if you look at Chief Justice Roberts' opinion in Trump versus Hawaii. He refers to the states, the respondents, pointing to all these statements by the president, just expressing the most blatant anti-Muslim sentiment, and said, well, let's set that aside. We got to think about how this ruling will affect any president, not this president, right? And so it was really disingenuous because the Supreme Court is setting forth the law. And the whole point is that they now are confronted with this president doing and saying what he's doing and saying, and yet they gave him a free pass. And so I think it was, they didn't, one thing I will say about Trump versus Hawaii, to the court's credit, is they did reject flat out the administration's arguments that the court could not adjudicate the issue, right? They purported to apply the Mandel standard. Is there a bona fide and legitimate reason given? And the Fourth Circuit had done that as well, and reached the different conclusion, Mandel with teeth, Mandel not as an empty letter. And the Supreme Court purported to apply Mandel and said, we are looking at the justification, but we find that the Muslim ban in its third watered down version does pass muster. In the census case, I was very worried that, if you follow the reasoning of Trump versus Hawaii, we had the Secretary Ross in this case, pretty blatantly up to no good. I think he clearly lied in his testimony before Congress about the reasons for the citizenship question being added to the census. He lied about whether the idea originated with the Justice Department or with his department. Thank God, or, thank Chief Justice Roberts, they reached the opposite conclusion in the census case. I think, the kind of, again, to go back to the legal realism lens, I think, the census case is one where it was so political in a way that was so blatantly rigging, rigging the system for the next redistricting battle in favor of Republican states. Maybe that also gave the majority pause. But yeah, I think
though for intellectual honesty, I have to make a note, just for the law school audience, that Supreme Court did not say that the administration did not have the authority to add a question. They just said they did not do it right way, just as a matter of record. But Kim, let me just turn to you before I turn to David for his last question. This is obviously, Europe is in the state of California, but this is a debate going on all around. Is there any coordination going on among states to do this in a more cohesive way?
Yeah, there are, in addition to the litigation, and certainly our Attorney General has been, if we call that partnering with other states in litigation efforts, but I would say more in a programmatic space, and what we're doing on the ground is really thinking about not only the legal service effort that I mentioned that both New York and Washington State also have made investments in, but also in looking at the broader immigrant integration strategies. So we're sharing and combining strategies, resources, materials, not only related to how we're doing communication around some of the proposed rules and policies, but also on the broader economic mobility strategies, education, access to services, and so forth. So there's certainly been some convenings and conversations for states that are interested and have that same priority in the population that's been moving forward.
Great. So those of you who want to ask questions, please get and line up there. We'll do this in exactly 5 minutes. And I will turn for last question to David. So David, with all this lack of hope we have had all morning, but I hear there is some hopeful sign on some decent bipartisan legislation moving in the House.
So we're hopeful. As I noted earlier, we need to start laying the groundwork for bipartisan reform. We've always put everything all together and always, kind of attacked the issue comprehensively. As you know, it's comprehensive immigration reform, right? This is the catchword, right? Or phrase. There was a realization after this administration came into power that was not likely, and so there have now been attempts to try to move things in a more piecemeal kind of fashion, the DREAM Act being one of those things. But here there's been a group of members, a bipartisan group with some conservative Republicans and some less conservative or liberal Democrats, kind of working on an ag labor deal. This is an area where we think, it is easier for Republicans to, provide a path to legalization and increase the number of visas that are available, for example. And so under the theory that you got to take baby steps sometimes before you can run, we have been working on a package that both provides a good legalization program for undocumented farm workers to come out of the shadows, that provides reforms to the current H-2A program to make it kind of a more streamlined program, kind of an easier to use, kind of more business friendly, but still protect workers kind of program. And then if we can get all that working, enforce it by, and I'm afraid of the reaction from some in this room, by also, by also then, instituting mandatory verify in the agricultural sector as a kind of way of, as the kind, those are the trades, and that is what. But again, I don't believe that you're ever going to get a legalization of the undocumented farm workers without doing the other two pieces. And so in the interest of moving the ball forward, building bipartisan support, getting members to talk to each other and feel like we can do things in this area, this is an effort that we think is worthwhile. It is very meaningful to me. Something that I've wanted to champion for a really long time. We're working with, NGOs and, United Farm Workers and Farm Worker Justice, and then grower associations and people across the political gamut. Anyway, so I'm very excited, and I hope that we can at the very least pass out of the House. We have some conservative Republicans who are rooting for us to get it out of the House so that they can take it, try to move it over in the Senate. It might come back differently than the way we send it over, but we'll see.
But any reason to believe the Senate has an appetite to do this?
Well, there are. Yes, and there are a lot of there are some important Republican senators who are in discussions with us and the Republicans that we're speaking to, and who are rooting for us and know what our package looks like and would like to see it come out of the House, and they think they can take it over there. Now, will McConnell let it go to the floor? Will this president and Stephen Miller see it and excuse my language, crap all over it and kill it? Yeah, I mean that's very possible, but you got to try, right?
But having seen this debate over the years, do you think that kind of deal-making is a down payment for the larger deal at some point?
I think so. I think that the idea, our idea is this is a mini CIR, right? This holds the promise of comprehensive reform, right? You have a sector that clearly is dependent on immigrants. You have a lot of very conservative Republican farmers who recognize that and go to their Republicans and say, we need these people. You can't just deport them. If you deport them, we close down, and we can't just replace them. There are a million of them, and they know what to do. They know where to go. They know how to pick our crops, and they feed our country. And they're willing to take political hits. And they can do things back at home, and they can talk about that population in a way where they don't get the political blowback that you see in other areas. And so we're hoping that by, and they're saying things that you would normally not hear very conservative Republicans say. And we're hoping that, that takes. People get comfortable with that. And that, if you can show how this can help improve that sector and, both be business friendly and worker friendly and also enforce it in a way where it doesn't be, you can argue that it's not a magnet for future unlawful migration. And forgive me, I'm still stuck in the old ways of talking. Can I just say, I wanted to say one thing, because this might be useful. I know you said that we need to stop talking about, for example, we need to lose the phrase, get right with the law. Maybe, but I will say that you have to understand, if you're going to achieve political success on the Hill and get legislation through 2 houses and get it to a president to sign it, you have to understand the other side. We're never going to get everything we want. I just don't believe that's ever going to happen. So you have to understand how to compromise. You have to understand what the other side wants. You have to understand what motivates them, how they think. And they do, this is, many of you know that this is the way I think, right? I think Democrats and Republicans, liberals and conservatives are kind of wired differently, right? We're wired to be justice oriented and outcome oriented. Like, what's a just outcome? And how do we get there? And how do we interpret a law to make sure that it results in the most just outcome? And Republicans really, they come at it by saying, what are the rules? And it's black and white, and did you follow the rules? Did you not? What does the law say, and what doesn't it say? And that's the way they approach the issues. And once you understand that they have a real legitimate, some of them are motivated by other things. But those who are motivated by just rule of law, and some of them are, you have to figure out how to deal with that. And it is about, they get that the rules were antiquated and that there aren't legal pathways to really meet our economic needs, but you still have to recognize that people did something unlawful or here unlawfully, and you can't just hide it. And so you have to provide a way to get right with the law, or to become lawful, or to at least legalize your status, however it is. You're not going to be able to get around that kind of rhetoric. And I think trying to do so maybe creates even more distance between the two sides. So that's my take. But
okay, I know you want to speak, but I have
sorry, no, you can't. I hope that's
2 people at the mic, and maybe we'll get
Sure.
your answer to answer one.
Oh, sure.
So, Camille, do introduce yourself.
Sure.
And ask a question to who you want.
Hi, I'm Camille Mackler. I'm from the New York Immigration Coalition. I have a question for Cecilia, but David, maybe we can speak more offline, because I want to make a plug for year-round dairy farm workers and your H-2A reforms.
They're in there.
Okay, good. I'll let them know. Cecilia, I have, I guess my question is, given, especially with the backdrop of how this president and his administration is really just destroying what it means to be an independent judiciary. We see that every day in immigration courts, how many of these deportation orders are unjust in the first place. But also how they're reshaping the judiciary, the bench, right, the federal bench. I worry that all of these lawsuits, eventually, the way that they are reshaping the way the executive impacts and has the enormous powers that they have on immigration policy, that it's going to backfire on us in the long term, because if Congress doesn't get its act together, no offense, but not much hope either. And so if we're stuck with this for the long haul, and we're reshaping how the executive interacts with immigration policy through our courts, which they are themselves reshaping, it's just sort of very convoluted and complex and dangerous. And if you take it a step further, you leave the Beltway, you go into the communities. These are extremely hard decisions to message to communities. And when I'm sitting in an upstate New York County jail talking to a woman who came from Texas, got caught at the Canadian border because she got turned around when she was trying to flee because she heard that our president on TV said, we don't want asylum seekers, it's really meaningless that the Ninth Circuit said, well, remaining in Mexico is illegal, but you didn't prove your requirements for a TRO.
Okay.
Mm-hmm. So I guess I have 2 responses. One is, what's the alternative? If you don't challenge these policies, they are the law, right? And so I think, yes, we should pick and choose our battles. We should be mindful of counting votes in the Supreme Court. We should try to figure out how to avoid certain courts that we believe will be inhospitable, and there are different tactics we can use to try to do that. But I think at the end of the day, I'll start with my lesson one, in my opening remarks, which is we don't have any choice, because if you don't challenge the policies, you don't get relief, and they become the law. Of the 8 major asylum policies that we've challenged through, big systematic cases, all of them except for the third, the asylum ban number 2, are currently enjoined. And so, I think we have to, yes, we should be careful about the collateral impact of losses as well as victories in litigation. That's certainly right, and I totally hear you about how we talk to affected communities about the lawsuits and orders in them. And we should be careful about how we bring cases and which cases we bring, but I don't see any alternative. Otherwise, we'll be stuck with what we've got. My second, my second.
I agree with that.
The second response is that, actually I have 3 responses. The second response is, I actually think there's a limit to what an Article 3 judge is willing to put up with. I think this president is extreme. I think we've seen plenty of Republican-appointed judges, federal judges, ruling against this administration. And, the overall arc of immigrants' rights litigation and other litigation touching on the immigration power, and more broadly foreign affairs power that's related, is that, I came back to the ACLU in 2004 to litigate against the George W. Bush administration's torture policy. And all we had to do was walk into court and hear the government lawyer, DOJ, say, I represent the United States national security, end of case, you're dismissed. And that's not the case anymore, even with Muslim ban, which doctrinally is a relatively tough case about the president's exercise of power under 212F. And then finally, the third very quick point is, I think, our siblings in other social justice movements are thinking a lot about how to avoid the U.S. Supreme Court now. A lot of them have more options than immigrants' rights advocates do in state court. But we do have state court avenues, and we've gotten a lot of interesting results in state Supreme Courts on detainer policy under state constitutional law, for example, or through state legislative relief, as in California. So that's my 3-part answer.
Thank you.
Great, thank you. And please introduce yourself.
Thank you. Penel Ibe with the American Friends Service Committee. My question is with regards to TPS and DED, and so I have sort of 3 questions for each of you. So for California, California has a large population of TPS holders, and just wondering whatever happens with the courts or inaction or action of Congress, is there a plan for the road to undocumented status? Because there's families involved, and like you said, it's multi-status families. For you, Cecilia, I don't think ACLU is litigating on any of the cases, including
We are
DED.
actually.
Oh,
We're
okay.
doing one in Southern California. Mhm.
So what does the road look like? Is there a path to the Supreme Court? The Ramos v. Nielsen hearing, one of the readouts was that it's more likely that the Supreme Court will take it up if the government requests it, not the plaintiffs. And so if you could just talk about the landscape for that, and DED in particular, also in the context of foreign policy, because these are individual countries, and we hear like through the third country, safe third country agreements, for example, El Salvador, that was brought up. Like how does that play into the decision? Can that be brought to a court? Like what happens in the courts? There's a whole lot, I don't know, but if you could share. And just for you, David, when you bring up TPS and DED in the room for like when you're trading and battering lives, what does TPS bring up? Because that is what is happening with the programs. And when immigrant rights advocates say, do not pit other immigrant communities against each other, we don't want you to uphold Daca and then throw enforcement into communities. How do you sort of make sure you represent that voice in the negotiations?
Yeah, I mean, well, so
Thank
Sorry,
you.
I don't know why I'm going first. I know, I have no idea why I'm going first.
Think more.
That's okay.
I'm working on
the
2
people.
hours of sleep. I've been traveling. I just want to say that.
So Kim, why don't you start with
Just
this?
very quickly, I've mentioned the investment that California's made in supporting immigration legal remedies for populations. We have, over the course of this multi-year investment, targeted different populations and strategies. TPS has been one. So we've had focused dollars and commitment and resource to support those who are TPS, the TPS population across the state, and also just ensuring that we're not missing anything in terms of any other potential remedy that they might be eligible for in that connection.
David?
Okay, so one, I don't know if you know this, I don't know, oh, there you are. TPS DED is in the DREAM bill, you know that, good, just make sure, Dream and Promise Act. I actually think it's easier to deal with TPS and DED than it is even the DREAM population because of, one, how long they've been here in a lawful status, and so, it's an issue where a lot of Republicans didn't even know it existed. A lot of Democrats didn't know it existed until very recent, until the administration decided to, no longer continue to issue TPS designations. Again, I will reiterate that no matter what we do, it is likely going to require some kind of trade-off. That is just the way our institution is built. It is not, it's just, I just hope that what you're hearing is a reflection of reality and not necessarily kind of a normative kind of statement. But, there were times where, so the big grouse or the gripe from the Republican side with TPS or DED is that it was a temporary program, and if you look at the statute 244, there's a lot in there to actually say like, hey, we really mean this to be temporary, and indeed it actually says that any effort to move a bill to provide permanent residence to TPS holders, is subject to a point of order in the Senate. That's how much, right, when Congress passed it, they wanted to make sure that they codified this idea that this is to be temporary and temporary only. So they're upset that it wasn't temporary and that every administration, you've got DED holders for almost 29 years from Liberia, and TPS, rightfully so, by the way. I am not trying to, but that is their gripe. And so there were times where there were offers to provide permanent status to TPS and DED holders, but change the statute to make it even more, kind of just make it temporary, right? We mean it's temporary for real this time, kind of language, and we've never moved forward with that. I'm not sure that that's even possible now, because I think this administration would want a lot more than that. But it was one of those things where there's a lot of confusion on our side as to what a good deal is and what it isn't. And if you were to ask TPS holders, a lot of them would say, that's a great deal, do it. You get to protect the people that are here now, and you're potentially making it harder for people in the future to stay, but that's a trade-off worth making. Others don't agree. And then it splits us, and we don't ever coalesce around a particular idea, and so nothing happens. That's just a real dynamic that I'm just trying to shed some light on. I can't tell you now that I know what we would do or what the right outcome is. I will say that hopefully if there's a cliff and there are people who have had status for 20 years or 30 years and they're about to lose it, that will be an easier thing to get across the finish line, even if it's temporary.
Okay, I have 2 minutes left, and we didn't have much control over how we began this conference, but we have a lot of control over how we'll end it. So I just want to give last 30 seconds each to all our three panelists, that if you had to ask from your respective perches, if you had to ask this audience what they could do to improve or help the kind of work that you do, what would that be? Start with you, Kim.
Well, I think since we're here, I'll tailor my message to the students, and that is thank you for signing up and making this commitment. Keep going. I think one thing I'm certainly grateful, in addition to the investment we've made an investment in capacity building. So fellowships, really building the capacity of the community to be present and support populations in our larger immigrant integration efforts. So thank you for being part of that capacity building effort, and please continue on that path.
Okay, other than joining the ACLU, what could they do?
Hopefully, they're all members already. I think I'll end with, what I started with and rebut what David said. I think,
I knew it was coming.
look, I don't like to think of myself as politically naive. I really don't think I am. And I understand that anything that happens legislatively is going to be the product of compromise, and there will be wins and losses involved. But, when I say that we need to move beyond the language of lawbreaking and the frame of lawbreaking, I really mean that for those of us in the movement, and hopefully for those of us who, those in Congress and in state houses who represent our views, for those of us in the movement and immigrant communities. In the summer of 2014, the Obama administration was talking about a surge, and the president, vice president, and secretary of Homeland Security declared that nobody coming from Central America was eligible for asylum, and they would detain and then rapidly deport people explicitly for deterrence purposes. And it's not that far a leap from a surge to an invasion, and it's not that far a leap doctrinally from detention at Artesia and expedited removal to what we see now. Legally, I think there's a big difference. And we sued the Obama administration in the summer of 2014, just as we're suing the Trump administration now. But I think it's important for us not to buy into those frames.
David, you get the last word.
Sure. Just two things I want to say. One, belief, and having a belief system and being true to your values is extraordinarily important. But being true to your values and not having the power to do anything about it doesn't get us very far. We need to be politically engaged. I think people need to vote. The fact that the Congress hasn't done much is a reflection of the fact that we control one house, and that is a reflection of the fact that we just haven't been able to win the Senate, and we lost the presidency as well. Some people didn't vote for Hillary Clinton and they voted for Jill Stein or someone else because they couldn't vote for her, but there are consequences to that, right? You need, for the people who stand up for immigrants to have power. You need that to happen. Those are the people you care about. And the other thing I would say, and last thing, is challenge yourselves a little bit in the sense of, what's difficult if you're on the Hill, is that, we don't think of ourselves as gods or we know what to do. We have to go to the outside and go to the immigrant communities and NGOs to really understand what a good trade is, or a good policy is, or we need the support of the communities. And if they're all over the place, or if they're in a kind of a no trade mentality, we want to be pure, then it makes it very difficult for us to to cut a deal of some kind. So I just say that because that's just something that I've recognized in my time as well. So you at least need some voices on the outside, maybe not, vocally, but at least in the room, to be very pragmatic and to be able to help guide us in a way that, we feel that we can move forward and that we're not violating our values. Sorry, thank you.
Please help me thank Kim, Cecilia, and David.